Hello and welcome to Bulletin 134, the March 2021 Bulletin. Three cases of interest. The first is a case of reconic, where an application was made to remove an executor. The executor had kept the beneficiaries informed, was not alleged to have committed any misconduct in the performance of his duties. However, he had brought an application for an estoppel, which involved the second spouse, who was the person who'd applied for his removal, on the basis that there was a conflict of interest. The court said yes, there is a conflict, but the conflict will be resolved by the court, and therefore they saw no need for him to be removed and add to the cost and potential delays in the administration of the estate. Just an interesting case in relation to a conflict, not causing somebody to be removed as an executor. The next case was a family provision case, and in this case the person who brought the claim was declared bankrupt. She declared herself bankrupt, actually. There was a question then about whether in fact the claim fell within the bankruptcy trustee and bankruptcy domain. The court said the right to bring a family provision claim was not a shows in action or other species of property that vested in the trustee in bankruptcy. However, her action was stayed under section 60 subsection 4 of the bankruptcy legislation, and she could bring her family provision claim after she was discharged from bankruptcy. Just an interesting case, I thought, where a person's bankrupt in the course of bringing a family provision claim. The final case is a construction case, Di Lorenzo and Di Lorenzo. In that case, the provision of the will was to divide shares in a company of which there were two, equally amongst three people. The interesting thing was that the case, the will that is in the case, said that the daughter, a lady called Joanne, was to receive more of the shares if they were not divisible by three. She alleged that since they weren't divisible by three, they should all pass to her, and the court wasn't minded to put that construction on it. In fact, said that look, it could be held by them as trustees for them all, the two shares, and the only thing I felt of interest of the case in particular was why a share split or share division hadn't occurred as part of the estate planning. They obviously knew that the shares may not be divisible by three, and yet it seems that nothing was done. May have been other good reasons, I'm not sure, but certainly always worth considering a share split if you've got, say, 4 beneficiaries and you want your shares to be divisible equally amongst the 4 beneficiaries. Finally, just point out that there's a reference to a change in any distributions of an estate, a deceased estate, where the distribution is being made to a foreign resident. That's no longer benign, and you should look at what is said in the bulletin about that. Just a warning, came in on the 1st of January, so there'll be estates probably towards the end of the year where there may be the potential for a distribution to a foreign person, and please make a note of that particular change. I'll leave it there. Thank you.